This is Colin O'Keefe here once again for LXBN TV. In the most closely watched Supreme Court case this term, the justices ruled that when citing religious reasons, closely held businesses do not have to abide by the Affordable Care Act's contraceptive mandate. Joining me now to explain the case and its potential impact is attorney Robin Shea. She's with the Constangy and author on the firm's blog, Employment and Labor Insider. Robin, first, can you kind of walk us through the ruling here? Why did the justices rule the way that they did? What's the rationale for their decision?
I think the overarching rationale for the decision was the very broad language protecting religious beliefs and practices in the statute, the Religious Freedom Restoration Act. It was not a First Amendment case, and the statute was actually more protective of people's religious beliefs and practices than the First Amendment is, believe it or not. And so that was the law that the Supreme Court was working with. And I think what they said was they took what I consider to be a very organic approach to business, that businesses are made up of human beings, and human beings have religious beliefs. And, under the Religious Freedom Restoration Act, they don't have to check those beliefs at the door if compliance with the generally applicable law would be a substantial burden on the practice of their faith, and there are less burdensome ways for the government to achieve its goals. I think it's really important. I know there have been a lot of people who have been very critical of the decision, but I think it's important to remember that the Supreme Court has already said that the Affordable Care Act is legal, that contraceptives are legal, and that it's legal to require that contraceptive coverage be provided without cost sharing. So they've just carved out what I think is going to be a pretty small exception for these closely held businesses that have very sincere and fervent religious beliefs that would say that providing that type of coverage, at least in some aspects, would be a sin.
I see. And then second, what's the impact of the ruling here? You've alluded to it, of course, and I've heard others say that it's somewhat narrow, and then another camp say that this is broad and sweeping and opens up the possibility that other businesses could not abide by laws for religious reasons as well. But what are your thoughts on where this ultimately falls in that spectrum?
I don't think it's going to be, I definitely don't think it's going to be a disaster, and I doubt that it's going to be a very big deal for most people. The government is already trying to come up with a workaround so that women who need contraceptives will be able to get those even if their employer has a religious objection to providing that coverage for them. So I don't think there's going to be a long-term problem in that regard. And the other reason I think the impact will be small is one of the requirements to qualify for the exemption is that you have a sincerely held belief. And there may be employers who say we don't want to cover contraceptives because it's too expensive for us, but they're not going to be able to do that. These employers in this case had worn their religious hearts on their sleeves for 40 years and took out full-page newspaper ads proclaiming Jesus Christ as their Lord and Savior. These guys were sincere. And, there may be Johnny-come-latelys now, but they are probably not going to win on that sincerity part of it. And I also think the overwhelming majority of employers are just going to go along with what the law requires, and they're not going to have any problem with it. The Supreme Court also said, specifically, this is not necessarily going to apply to employers who have religious objections to providing immunizations or vaccinations, or who believe that their religion requires them to discriminate against people. They've said it's not going to apply in those situations, probably. They didn't completely close the door, but they indicated they're not going to be very receptive to that type of claim. And then the other thing I think people need to remember is religion is not monolithic. Even within, just within the the Christian faith, there were very sharp divisions about this particular case, and I believe there were amicus briefs presented on both sides from different Christian organizations. And then even within a single denomination, you're going to have people who are very fervent in their beliefs, who are usually a small minority of the whole group. And then you'll have people who disagree with the teachings of their own denomination, and there are going to be people who just don't care. And so I think those folks are going to be in the majority anyway as a practical matter. So I just don't see this case as having nearly the dramatic impact on women's ability to get contraceptives that some people have said it will.
Definitely, definitely. There's been a lot of uproar around this, but as you mentioned, this is a pretty narrow decision, and though there are still certain details to work out, this doesn't have the broad, sweeping negative impact that many people fear it might. Once again, that was attorney Robin Shea. She's with Constangi. For more of her impact on this ruling, be sure to visit employmentandlaborinsider.com. Thanks for joining me today, Robin. It's a pleasure as always.
Thank you for having me, Colin.